Good morning, everyone. Thank you for tuning in. You've reached the Real Estate Fix. I'm your host, Rich Szerman, on KHTS, FM 98.1, AM 1220. Happy Friday to you. Thank you guys for tuning in. I appreciate it. We're going to do something a little bit different with the show this week. Usually we do market wrap-up stuff to begin the show. That's usually our first segment. We move on to other things. But I have seen so much stuff in the last couple of weeks about zombie mortgages. The amount of them that come into my office and the amount of them that we're dealing with now, it seems like there's a tidal wave of these things that seems to be building up, getting more and more and more. So we're going to talk today all about zombie mortgages, what they are, how they got created, if you may or may not have one, and how to fight them if you do, and most importantly, what needs to change so these will go away. Because those of you who don't know what a zombie mortgage is, that is great. It's good that you don't know. Those of you who do know, it's probably because you or a family member or a friend or somebody on your block got nailed with one of these things and likely lost their house or lost a chunk of their equity at the very, very least. So we're going to talk today all things zombie mortgages. So zombie mortgages and how to fight them. And time permitting, we'll get back into some market stuff at the end. And if not, we'll just do that next time. But anyway, zombie mortgages. So let's start here. What is a zombie mortgage? That's what you get most of the time. A friend of mine, a friend of the show, a friend of mine, personally, Lou Esmond, and I coined the phrase zombie mortgages, almost 20 years ago, talking about these. And I think it's inaccurate. Sometimes you hear them as ghost mortgage, but I think zombie is more accurate. A zombie mortgage is a loan that you thought was paid off, was gone, was destroyed, usually in a bankruptcy, loan modification, whatever, but you thought was gone. There was no attempt to collect for several years, and now all of a sudden it's coming back to life. That's why we call it a zombie, to eat your equity. So I've got a lot of stories about this. I'll give you an example. I have a new one in the office, just came in the office this week. Very, very nice lady. She's been in a very nice house in a very nice area for a very, very long time. She's owned the house for, I think, 26, 27 years. 16 years ago, she did a loan modification. She had a first and a second. She was told by her, she had a bankruptcy and a loan modification. She was told by her bankruptcy attorney that the loan was discharged, the second loan, which technically it was, but I'll explain that before we get done with the show here, but it really wasn't. It was taken off of her, but it's still attached to the house. We'll talk about that a little bit later. So she thought it was discharged, then never heard from the bank on the second. On modification, they told her that it was being combined, or at least she was led to believe that it was being combined, which they do not do. We'll talk about that as well. And so all of a sudden, here we are 16 years later, she gets a letter in the mail that says, hey, congratulations. We know you only owe about $800,000 on a house that's worth about $1.5 million. And guess what? You had a $70,000 loan that you now owe us. I think it's $158,000 if memory serves, because that debt has gone unserviced for the better part of 16 years. And so now you're rather, what would be considered comparably a rather low loan at 50, 60, 70,000, something like that, is now 158 grand, roughly 3 times the amount you originally borrowed. Please cut us a check in the next 90 days, or we're going to foreclose and take your house. That's what a zombie mortgage is. It's usually a junior lien. It can be a senior lien, but it's usually a junior lien, and it's a debt that is attached to your house that you thought was gone, you thought was dead, and now it's coming back to life to eat your equity and mess up your life. Because in that particular client's case, she's looking at retiring in a couple of years, and now a big chunk of her retirement, which was going to be in her house, has gone away. It's interesting. There was a survey that was done just before the pandemic that I reference a lot. AARP did a survey, really good sample size too. It was over 100,000 people. Most surveys are about 1,000 people. So it was a really good survey size. And what they determined is 98% of all those surveyed who were 65 or older said they needed the equity they had built up in their home in order to be able to retire. Not to retire well, but to be able to retire with the basics, housing and food. So I don't know the 2% who doesn't need that, but glad to know there are at least 2% who don't. So if you have any hope of retiring realistically, at least in California, I would say the entire United States, you need the equity built up in a home. And these people, these people who work in these markets, I call them vulture capitalists. I call them other things too, but we're on the radio, so we'll be good about it. They come swooping along. They buy these debts for pennies on the dollar, and then they seek to enforce the total amount of the debt, including the past due amounts and everything else. And what kills me about it, and I say this over and over again, it is completely unethical, it is completely immoral, but it is legal. And that's the problem. Whenever you have something that is unethical and immoral, and I think we can all agree on that, not doing anything to collect a debt for 16 years and then suddenly coming out of the woodwork to say, now you owe us $158,000, I think is an unethical thing to do. Because they know darn well there was no real attempt made to collect this debt. They knew darn well that the homeowner didn't know about it. That's what made her a target. So it's because, 20 years ago had they done this, or 10 years ago had they done this, she didn't have the equity she has now. She could have filed a Chapter 13 bankruptcy and wiped it out. There are a lot of things she could have done. Now she can't because she's got equity. A lot of it as well. So that's what made her a target. So they wait. They wait with these things. They get sold off from bank to bank to bank. And then somebody buys it. Some sort of bottom feeder buys it. I call them that because that's how I feel about them. Economic bottom feeders buys it and then seeks to enforce the total amount of the debt. The guy who bought this $158,000 debt, the company that bought it, they maybe, because this is a juicy one, they maybe paid 50 cents on the dollar of the original debt. So they paid $25,000, $30,000 for this debt, and now they're seeking to enforce a $158,000 lien. That's pretty profitable. And we'll talk about first loans and how that stuff works as well. So I don't want to get too much into the weeds here at the top, but just know that is what a zombie mortgage is. It is a loan that you thought was dead and gone that has come back to life to destroy your equity and screw up your life. That's what they do. That's what they are. And everyone has them, it seems. We're seeing more and more and more and more of them. We've had 3 just to come into the office just in the last week. And that is a lot even for us. We see a lot of this stuff, but that's a lot even for us. And I'll also say at the top here, if you do wind up with one of these things, you think you have somebody who knows one, I did not set out to become a national expert on these things, but I am. However, unintentionally, simply because a lot of people don't get into this field and don't know how to handle it if they are. But we certainly do, and we have quite the success record with this. If you do know somebody who's having a problem, have them give me a call, or you give me a call, I'll call them, whatever you want to do. But my phone number is 661, give this out every week, 661-714-1400. We'll say it again at the bottom half of the show as well, 661-714-1400. That is my personal cell phone. Please don't call me while we're doing the show. But you can call me or text me at that number anytime, 24 hours a day, 7 days a week. If you do call and I don't answer, please send a text and I will call you back as soon as I can. 661-714-1400. Okay, so now that you all know what zombie mortgages are, let's talk about how they get created, because that's incredibly important, because you may have one and not know it. I find most people have no idea they have these things and they come back to get them. And there's a big difference between you realizing what's there and going after it versus when they realize what's there and come after you. There is a big, big difference between where you are in that process as far as the success and what you can get out of it. If you discover you have one of these and you chase down the loan and you seek to kill the thing before it has a chance to get you, there's a very, very good chance you're going to have a very good outcome. If you don't do that, and then some collection company picks this debt up and they come after you, maybe 16 to 20 years later or more, I think we had the record we had was 22 years, 27 years. 27-year-old debt, no attempt to collect for 27 years, suddenly the debt is still good. Amazing. No significant statute of limitations in California. It's one of the things that needs to change. But anyway, so we're going to talk about how these things are created, because you may very well have one. So zombie mortgages typically come out of not all, but a lot of them, the majority that we're seeing now, came out of the financial crisis of 2008. What happened, to refresh your memory, in 2008, there was nearly a banking collapse, but especially it's led by the mortgage sector. There were so many foreclosures, and there were so many runs on the bank. The TARP funds came out. There were billions of dollars pumped into the banks to straighten these things out. We can rehash that some other time. It really lasted between 2008 and 2010. I would say it lasted until 2012. But it was economic Armageddon is what it was in the housing market. We kind of all made our way through it. And what happened in a lot of these is that there were a lot of people who had loans from Countrywide, for example. This is very popular with them. They're not alone, but they did a lot of them, where they did like an 80-20 loan. This is before the crash. So you'd have an 80% first, you'd have a 20% second. That's 2 loans. The crash comes, you go to Countrywide or whoever your loan was with, and you get a modification, or you file bankruptcy, or both. But you're only dealing with the first. And a lot of people were told 2 horrendously bad things. They were told that their loan was being bundled, which it wasn't. No bank did that I'm aware of. There's no facility through the HARP plan or the HAMP plan or any of those programs that are out there to bundle loans. You could get a modification on a junior loan. That came after 2012. Before that you couldn't, but you could not bundle them. Any bank that has told you that you had a first and you had a second, and we put them together for this modification, is they're either lying flat out or they're just woefully uninformed. That is not the way it works. I've only ever seen one, and it was with a private lender, and even then I was surprised to see it. If they started as 2 separate loans, they are still 2 separate loans. If you did a modification on the first, great. That doesn't mean you touched the second. So if you did a modification on a loan, you had a first and a second, and you did a modification and you thought that sucked up the loans, plural, like you took a loan from, 2004 to 2008, and you had one of these, there's a very, very good chance you have a zombie second lurking in your title. And it will wake up at some point, and it will come to get your equity. These are scary, scary things. They always come at the worst possible time. I don't know if there's a good time for it, but they always come at the worst possible time. And they will take your house. They absolutely will foreclose. I have seen it. I have done it. I have been through it. We have tried to defend people from it. Some people just don't follow our advice, and yeah, they absolutely foreclose. We had a client some years ago who swore up and down they can't foreclose, and they did. We'll talk about that as well, too, because how they foreclose and how the economics of this works is important. So they're usually created as a result of the financial crisis, although they don't have to. It could be a debt that you got somewhere along the way that they just stopped collecting on. Maybe you filed a bankruptcy. So if it was a loan modification, you're told they bundled the loan. They did not. There was no, is not going to be any. It cannot happen. You may have done a modification on the first and another on the second. That's fine. You may have refinanced the first and you may have refinanced the second. If you refinanced and paid them both off, great, then it no longer exists. But if you did not do something to deal specifically with that junior lien, usually a second, then it still exists. Hear me when I'm saying this. If you did not deal with it, just because they didn't come to you does not mean it went away. So it's living like a cancer inside your title, and you best deal with it or it's going to come back and get you. The other thing, the other main place we see these, other than in loan modifications, misunderstanding of loan modifications, is in bankruptcies. There are not a lot of very good bankruptcy attorneys out there. There just aren't. There are very few. There are a lot of good attorneys out there. I know some spectacularly good bankruptcy attorneys, but there are very few of them. There are very few actual certified bankruptcy specialists. As a friend of mine likes to say, there are lots of attorneys in California who do bankruptcy. There are very few actual bankruptcy attorneys. And if you do need a bankruptcy, you need to find somebody who's a certified bankruptcy specialist. I wouldn't do it any other way. I'd recommend Lou Esmond. We do a lot of stuff together, and I know Lou to be spectacular at this, particularly when it comes to mortgages. Matter of fact, he literally, this is no joke, he literally wrote the book. He's one of 16 named authors in the Bar Association's how-to manual. I'm sure the book has a better name than that. I call it a how-to manual, as to how to handle mortgages and bankruptcy. He's one of 16. He literally wrote the book. He's who you want to talk to. His name is Lou Esmond. He's fantastic. If you need his information, we can get it online with us. You can call me. I'll give it to you. But anyway, the problem with bankruptcies is, a lot of times people file the Chapter 7 bankruptcy. That's the most common bankruptcy. It's the type you're in and out of in less than a year. And with a Chapter 7 bankruptcy, it does not wipe out the junior lien. I'm going to say that again. If you just did a Chapter 7 bankruptcy, your second mortgage still exists. It just does. There is no capacity inside of Chapter 7. Feel free to check with a bankruptcy attorney. I am not an attorney, but there is no capacity inside of Chapter 7 to wipe out a junior lien on your home. And the really worst part of this is when you finish your Chapter 7, you will get a schedule at the end, a notice of discharge at the end. And it'll list all the creditors that have been discharged. Oh, my MasterCard has been discharged. I don't need to worry about that anymore. My this, my that, my other thing, all been discharged. That's great. And it will say under the second mortgage, whoever the carrier is, that the loan has been discharged. It's been discharged from you as a person, but it has not been discharged from your house. In other words, they still hold the collateral. So just because you got a discharge in a Chapter 7, and it may even say, probably does say that your second was discharged, it doesn't mean it was removed. It doesn't mean the same thing as your credit cards. They still have the ability to hold the collateral. So, because this happens all the time. A bank goes to seek collection on a zombie mortgage. The client says, well, I filed a Chapter 7 10 years ago, and it says right here, it says right here in my discharge that that was discharged, so they can't come after me. Done. Wrong. It separates it from you. It does not separate it from the house. It separates it from you as an individual. They can't come after you personally after you file a Chapter 7, but no bank is going to come after you personally in California. They want the house. They don't want you. There's no money in you. There's money in the house. You can always file another bankruptcy once enough time has passed and wipe out that judgment. Why would they want you? They want the house. That's where the money is. So it is still on the house. So if you had a loan modification and you thought it bundled in a second, it did not. If you have a bankruptcy and you thought a Chapter 7 bankruptcy and you thought it wiped out a second, it did not. Please hear me when I say that, because those are the two most common ones I see. And when the client comes in the office or we talk on the phone, they are stunned at those two pieces of information. And I get through a lot of, well, how can they do this? And that's not right. And I was told this. And they assume I'm wrong, which I'd love to be wrong about this, but I'm not. If you did a loan modification that supposedly bundled the two loans, no, it didn't. And your second still exists. If you did a bankruptcy and you were told your second was discharged in a Chapter 7, it didn't. It still exists. And just because they didn't try to collect on it in the last 10, 15, 20 years, or whatever it is, does not mean it goes away. In other states, they are time barred from going after zombie mortgages. In California, it's up to 60 years. It's actually 67 if you take the most charitable reading of the statute. 67 years, which is insane. We'll talk about that more before we get done. But I want you guys to have a clear understanding of where these zombie seconds come from, because I want you to look. I want you to think about your own past. I want you to think about your own financial history and your house. You may have one of these, and you finding it before they find you is huge. It is a massive difference. If you find it before they find you, you can cut a much better deal. They'll take pennies on the dollar typically to wipe these things out. If they find you, they're going to seek repayment of the entire debt, including all the past due amount and all collection amounts and everything else, including the past due interest, the whole thing. And if you have a debt that's sat fallow for 10 years, 15, 20 years, even at a decent interest rate like 4 or 5%, most of them are higher than that, most of them have around 8 or 9%, you can imagine how that payment builds on itself and compounds upon itself. It usually winds up being 2 to 3 times what you originally borrowed. So your $50,000 debt, and you got $300,000, $400,000, $500,000 in equity, so it's not keeping you up at night, even if you know about it, may actually be a $150,000 debt. May even be more than that, depending on the length of time and the amount of interest and the type of loan that was set up. So yeah, these are serious problems. So think about this. If you had a modification, take a look, pull your title. Call me, I'll pull it for you. It's no big deal. Get a copy of the title report. See if the loan is still on your title or has it been reconveyed. Because if it's reconveyed, it'll say it's off. It'll be there and say it was reconveyed. All gone, no more. If it is still on your title, then yeah, you need to deal with it and you need to check. And that's unfortunately the only way to really check, because people don't check their credit reports like they should once or twice a year. They certainly don't check the title on their house, but maybe once a decade, if that. And it's usually when they're buying, selling, or they're getting a refinance. And that's when these things come back to get you. So check. You've got to check. So zombie loans also come out of, zombie mortgages also come out of. Maybe you had a modification that gave you a deferment or a forbearance or something along those lines. Those can also be zombie loans. It doesn't mean just because they gave you a deferment that the loan went away. Or they gave you a forbearance. Doesn't mean the loan went away. It still exists. They just need to go after you for it, and then just put it up on the shelf. So it could still be there. So you've got to check these things out. And I don't mean to scare everybody who's listening, although if that motivates you, I'll scare you. You've got to work these things out. I have seen people lose their homes over this. I've seen people who thought they had $200,000-$300,000 worth of equity lose their homes because they were so busy being shocked that this cannot possibly happen. And it does, it can, and it will. And if you're not careful and you have one of these, it'll happen to you too. Because unfortunately, in the economy we live, in the place we live, this is the golden rule. What makes money will happen. And these zombie seconds are incredibly profitable. So if you have one of these, take care of it now. If you're curious, call me. I'll find out for you. It doesn't take long. But you've got to check. Now let's talk about the other type of bankruptcy that's very common, Chapter 13. Now again, I want to reiterate, I am not a bankruptcy attorney. If you really have serious bankruptcy questions, you need to talk to a bankruptcy attorney. And we have several good ones in town. As I said, I recommend Lou. I'm happy to help you out there. But anyway, Chapter 13 is very different than a Chapter 7. A Chapter 7 is a dissolution. Hey, court, I got no money. What little I have, we're going to break up among my creditors, and we go our separate ways. That's a Chapter 7. It's usually done inside of a year, usually done inside of a couple of 4 to 6 months. Chapter 13 is a reorganization. With a Chapter 13, that's going to take usually about 5 years. 3, 5, or 7 years, depending at the moment, I believe. So they're typically 5 years. Chapter 13 is a repayment program. Now, if you did a Chapter 13 bankruptcy, unlike a Chapter 7 in your past, and you had a good bankruptcy attorney, and the first mortgage on your house, this is important, the first mortgage on your house over-encumbered the property. In other words, you owed more on the first mortgage than the property was worth at the time of filing. You owed more than the property was worth at the time of filing. If that's the case, and you had a decent attorney, what should have happened is that attorney should have filed a motion to strip the second. Now I say should have because that's my opinion. I'm not an attorney again. To strip the second. And if you've done that at the end of your bankruptcy, the second will have gone away. Just because you did a Chapter 13 does not make this automatic. Within the Chapter 13, you have to have a motion, your attorney presumably, has to have filed a motion to strip the second. If you haven't done that, you might have met all the requirements to wipe out the second. You might have filed a Chapter 13, gone all the way through it, and you know what? Second still exists. So it's still a zombie second. So that's where some of those things come from. So if you have any of those circumstances in the last 15 years of your life, you had a second mortgage and you thought it was wiped out because of a bankruptcy, it probably wasn't. You had a second mortgage or third or fourth or fifth or whatever it is, a junior loan. The only thing this doesn't apply to are first mortgages, although we see some of those as well as zombies, but it's very rare in our area because properties are so valuable. But if you had some sort of junior lien, some sort of junior financing on a property that you thought was wiped out as part of a loan modification or a bankruptcy, there is a very, very good chance, unfortunately, that you are wrong. There is a very good chance that that loan still exists. And just because nobody's come after you for the last 20 years to talk to you about it doesn't mean it's gone away. What I would suggest is if you've ever had junior financing on a property, you should check your title. If you've ever had a second or third or a HELOC or anything like that, you should check your title. So I tell you what, let's go to break. Let's hear from some of the advertisers. We love hearing from them. And if you have any questions, as always, you can give me a call after the show, 661-714-1400. That's my cell phone. I'll give that out more during the show. But I'm your host, Rich Szerman. You're listening to the Real Estate... Sorry. Interesting day today. You're listening to the Real Estate Fix with Rich on FM 98.1 FM, AM 1220, your hometown station, KHTS. I'll be back right after the break. Hello, everybody. Welcome back. You're listening to The Fix with Rich on KHTS, AM 1220, FM 98.1, your hometown station. I'm your host, Rich Szerman. Thank you guys for tuning in, listening through the break. I appreciate it. Today we're talking about all things zombie mortgage. We just spent the first quarter of the show talking about what a zombie mortgage is and where they come from. They're usually the result of either loan modifications that were not properly explained to the client, or a bankruptcy, in which case, which also is not typically explained. Usually it's a matter of understanding. Most people, if they know the debt still exists, have done something about it. But when they don't know, that's when it comes back to get you. So that's what a zombie mortgage is. That's what I call it a cancer inside your title. That's what that is. But let's move on. Let's talk about what it is to fight a zombie mortgage. How do you fight these things? If you got one of these and it turns out you've got one, how do you fight one? And there's a big difference between, again, I'll say this again, there's a big difference between when you find it and go to the lender, or when the lender finds it and comes after you. Those are two very, very different scenarios. So let's talk about if the lender comes after you. Worst case scenario. You come home from work one day, you go through your mail, and you find a letter from a bank you've never heard of. XYZ Financial. FFCI is one we see a lot, or Gregory Funding is another one. A lot of these guys, SLS, we see a lot of these. West Coast Servicing now. A lot of these guys, they're again, I call them bottom feeders, and I'll call them other names as well. They're being nice because I'm on the radio. I don't like these guys at all. I find them just morally reprehensible. And I will tell you one quick story so you know who you're dealing with before I go into how we fight these things. Years ago, I managed to get myself, they have a convention, debt collection convention every year. And this particular year, this is, 15, 20 years ago, they were having, because I've been in this fight for over 20 years, by the way. I saw my first one of these about 22 years ago, and I thought it had to be fake. I thought this can't possibly be real. There's got to explain it to the bank. They can't possibly collect on a debt like this. And I was as shocked as anybody to find out that, no, they absolutely can. And that kicked off this sort of 20-year crusade, because we're going to talk about how to fix this permanently before we end the show this morning. Right, so let's talk about who you're dealing with. These guys are the people who buy these mortgages and seek to enforce them. They have this convention. This particular convention was in Vegas, so I thought it'd be fun to go to. And unfortunately, I don't have a lot to tell you about the convention because it made me so angry so fast that I had to leave the room. And their opening invocation for this convention of debt collectors, a fellow got up there and he said, "We are doing God's work by cleaning up America's debt." And having already had a lot of clients who were going through this, I guarantee you they are not doing God's work. A friend of mine liked to put it this way at the time: the God I believe in is not short of cash. But apparently the God that these collectors believe in is. Because the idea that they are somehow on some sort of religious quest to clean up America's bad debt while they profit hand over fist, I think every religious tenant has something to say about that. And it sure as heck isn't that you're doing the right thing. So yeah, frankly, it made me sick to my stomach. I had to leave the room. So I didn't get to see most of the convention there. But yeah, these are the kind of people you're dealing with. They have self-deluded themselves to the point where they think what they are doing is righteous. And you as the consumer who didn't know about this debt, didn't service this debt, nobody ever told you about this debt since the day you took it out, somehow it's your fault and you get what you deserve. Oh, including all the back interest and everything else. You should have known better. I mean, I guess when you're doing something so incredibly immoral and unethical, you have to have ways to explain it to yourself. And that's how they do it. They convince themselves that it's okay. It's not okay. It's not okay at all. So let's talk about how to fight these guys. First thing, check your title report, get a prelim, see if you got one of these things. But let's say they came after you. You didn't know about it, they came after you. You check your prelim, you see if they're for real. Was there a debt to begin with? Probably was, but let's check. Next thing, you want to write a letter immediately to the lender that wrote a letter to you. And you want to write them a letter that says, "Please consider this a qualified written request." Make sure you use those 3 magic words, because in the world you're entering into, semantics are important. They will often ignore you. Qualified written request just means you wrote a letter. But for some reason, when you say, "Please consider this a qualified written request" as your first sentence, they respond quicker than they do if you just write them a letter. It could be the same letter. Just start with that sentence. "Please consider this a qualified written request." There are 3 things you want to ask for in that request. You want to ask for a copy of the note that originated the debt. Prove the debt exists. That's number 1. You say, "I owe you the money, bank?" Okay. Prove it exists. Show me the note. And most of the time they'll have it. The next thing you want to ask for is an accounting on the loan that note created, going back to the inception of the loan. They have to give you that. It's in the RESPA guidelines, it's in the TILA guidelines, and it's in the Fair Debt Collections Practices Act, that if you ask for an accounting, because they're saying they owe you the money, they have to produce it. We caught one not that long ago where there was an 11-year gap. The loan was 15 years old, and it had an 11-year gap in the accounting. And the bank actually had the audacity to say, well, yeah, we noticed that too. When we caught them, of course, they didn't point this out. When we got the accounting, we noticed there's an 11-year gap in a 15-year loan. And the bank had the audacity to say, yeah, we caught that too, but we know the interest rate, and we know she didn't pay anything, so yeah, we know the amount's right. Do you now? You can't prove she didn't make a payment during that period. You can't prove anything. So I tell you what, in that case, what we did is we gave the bank an option. My client can take you to court, which is going to cost my client $25,000 to $50,000 or more and take about 5 years of her life, but she will win, and you guys will get nothing. Or we can find a way to settle this now. And I think the bank in that case, if I remember, agreed to settle for $15,000 out of the $180,000 they were asking for, so that worked. Still annoyed that she had to pay that money, but at least it got her out of the problem. So yeah, get a copy of that accounting and look through it. Also, and this is a biggie, people always forget this, ask for all of the assignments of the note. When the note was transferred from Bank A to Bank B, that's called an assignment. Whether they bought it, whether they're servicing it, whatever, it's called an assignment, and they must be filed. Otherwise, they don't have a right to service that loan. So you ask for three things. You ask for a copy of the note. You ask for all of the accounting on the note, going back to the inception of the note. And you ask for a copy of all of the assignments of the note. Because the bank that's coming after you is typically not the one you took out the loan with. If it was a Countrywide loan, Countrywide hasn't existed for the better part of 12 years. I think longer than that, since they effectively existed. Or some other, we still see some from Home Savings on occasion. That bank's been out of business for almost 20 years. So it's not like you can go back to the original originator of the note and do much with it. They are supposed to have that record. They're supposed to have the note. They're supposed to have the accounting on the note going back to the beginning. And they're absolutely supposed to have a copy of the assignments. If they are deficient in any one of those three areas, and that's just a place to start, then you have a defense that you can mount. And the idea, what we do in my office, and I think this works pretty well, is the idea is to put it together as if it were going to become a lawsuit. The legwork that you would have to do for an attorney so they could get started. Because if you build it in such a way that it looks like, acts like, and can easily be converted into a lawsuit, that is going to be your best way to defend the bank. Because the bank will understand that you are not paying them, you're certainly not giving them your house, but you are ready to push the button on a lawsuit. Because you've done all the legwork. In other words, you lay out the case. And then what you do is you hope that the people at the bank are wise enough to understand that a lawsuit is going to cost them money too, not as much as it's going to cost you, but it's going to cost them money as well, and it's going to be more difficult for them to succeed. The bottom line with any sort of foreclosure defense, especially with zombie mortgages, the bottom line is you have to put the debt under threat. You have to explain to the party trying to collect that you are not a wounded gazelle out on the plains of the Serengeti and they're going to pick you off easily. It's not the case here. You are going to put up a fight, a nasty, spirited, angry fight. When they understand that, that tends to soften the ground, shall we say. It's not a guarantee of victory, that's for sure, but it definitely softens the ground. It definitely puts you in a much better place. Also, emotionally and mentally for people. If these guys come, they're going to beat up on you and you think you have no option. I mean, if you've ever seen a dog that's been beat, people do that too. People can get beat down as well. People get depressed as well. People get to a point where they simply cannot function. I've got a client right now. She is a nurse, and she is a very, very bright girl. She's got her life together for sure, but she was basically stopped working for the better part of a month because she was so depressed and so wiped. She's the fact that this is a problem to begin with is enough of a problem. The fact that this is allowed to go on the way it is depressing. The system isn't supposed to work like this. When you're struggling to keep a hold of a house through the pandemic, through the economic downturn, through all the other stuff that's gone on in the last 10, 20 years, and you struggle and you make it, and in 2024, you still have a house. Not only do you still have a house, you have a house that's gone up in equity over the last 3 or 4 years, roughly 30%. If you're in California, you've got a house that you've been paying down the mortgage on. You are doing what you're supposed to do. You are securing your future and that of your family. And then all of a sudden, out of the blue, you just get a letter saying, by the way, you owe us a big chunk of, if not all of your equity, because they will wait until you're a target. And you're not a target. We were just talking off the air. If you owe $500,000 on a house and the house is only worth $505,000, they're not coming after you. No way. They'll sit quietly and do nothing. But if you owe $500,000 on a house and it's worth $1 million, and they have a note that they can enforce for 185, they're coming after you because you now are a target. They have identified you as a target, and now they're coming because now there's something to collect. Now, there probably wasn't anything to collect 5 or 6 years ago, and your house was worth a lot more money, or a lot less money, excuse me. There probably wasn't a lot to collect 3 or 4 years ago, and your house was worth less money, but there is now. So that's when they come after you. So you've got to be prepared to fight back. So the first thing you do is you ask for those 3 things: the note, the accounting, and the assignments. And you go through them. And if you don't know what you're looking at, I'll be happy to help. I certainly do. And you look for, the first thing you look for is reversible error. Is there anything in that note that we can use, or the accounting or anything else that we can use, like in the case with the missing years, that we can use to bring this debt under threat? What can we use? Again, we don't want to file a lawsuit. We don't want to have to go to court because it's expensive and time consuming. And by the way, I'm saying that as a guy whose wife is a real estate attorney. And when people do go to court, she gets rather well paid to do that. Well, that's not true. She takes a lot of pro bono cases, maybe not as well paid as we'd like. Thank you, honey. I appreciate it. A lot of those I sent her, so I appreciate that. And by the way, we do all this for free, just so you guys know, if I buried the headline there. I've been doing free foreclosure defense for people for the better part of almost 30 years. So, and we've been doing it for free the entire time. We don't charge for this. It's bad enough that somebody else took advantage of you. And the whole idea is to fill that gap between you doing it yourself and going out and hiring an attorney. So that's kind of the gap that we try to fill in for people. But I am certainly not an attorney. And there are all those times you flat out need an attorney. I mean, if a bank is intractable and you got a case, you need an attorney. You don't always need an attorney is the idea. You don't always need to incur the expense of an attorney. And that's the guy whose wife is a real estate attorney is telling you that if you can avoid hiring an attorney, unless you can find one who's willing to work for free, thank you, honey, you're better off if you can avoid that expense, if you can. You're already in trouble with this loan, with this zombie thing. The last thing you need to do is go pour more money into an attorney. But if that's what you need to do, that's what you need to do. And it's never a bad idea to have a consultation with an attorney. It is never a bad idea to sit down with an attorney and say, this is what's going on. What do you suggest? That is never a bad idea. What you do beyond that depends on your case, of course. So anyway, first thing we do is we take a look at the note. We take a look, see if there's anything in the note that we can find reversible error. We want to see if the note is time barred from collection. And that's a big deal because in California, unlike other states, it is extraordinarily rare that you're going to find a debt that is time barred for collection. It's a loophole in the law that we're going to talk about in the last segment of the show because there's some laws that need to change in order to put an end to this nonsense because this is legalized theft. That's what it is. It is legalized theft. And it needs to change, and it needs to be changed. What we desperately need is a politician. If you're listening to me, local politicians, we need somebody to decide to develop the backbone and the political will to go after this. So far, no takers. Been almost 30 years, no takers. But we'll see. I'll tell you a story about that before we're done, too. But anyway, the first thing we look for is reversible debt, reversible grounds. We take a look at this debt time bar. Now, in California, the way it works is, and this is just a ridiculous thing with the law, a deed of trust is typically only good for 10 years if the date of maturity is in the recorded document, if it's on the deed. And in California, they're never on the deed. Why? Because if the banks don't put the date of maturity on the deed, then the loan is good for 60 plus years. Your statute of limitations is longer than most people's lifetimes. I'll give you some fun examples. In, New York, I think? In Florida, the statute of limitations for zombie seconds, this sort of thing, 5 years. If they've made no attempt to collect in 5 years, they can't collect. In New York State, 6 years. If they make no attempt to collect, 6 years, they can't collect. That's Florida and New York. In California, it's 60 years. That's just the mechanics. If you look it up, it'll say 10 to 60. But it's only 10 if they have the maturity date in the note, which they never ever, in the deed, which they never ever do. Because if you were an attorney for a bank and you put the maturity date into the deed, your loan would not be as valuable because it's got 10-year collection on it. 60 years is more valuable. So they don't do that. If you're an attorney at a bank who did do that, you'd be fired because you just devalued the bank's asset. And that would be your loan. So it's ridiculous. 60-year statute of limitations. That is insane. Anyway, so you go through the note, you look for reversible error, you get the accounting, you get everything, you look through all of the good stuff, and you see what options you have by going through the data. You've got to dig it out of the data. Different states, different rules, as we talked about. New York, 6 years, Florida, 5 years, California, 60. Now, it is not an accident that the one state in the union that has more real estate sold per volume than any other state in the union, usually 5 to 10 times what most other states have. California has somewhere around 40% of all the real estate that gets sold in the United States on a yearly basis by volume is in California. The majority of that is in Southern California, i.e. our backyard. So when most of the real estate buying and selling goes on here, most of the zombie mortgages are going to be found here. And the reason that it's so profitable here, because they have a 60-year statute of limitations. You are not time barred for most mortgages until you reach the 60-year mark. So if they've not done anything to collect in, 60 years, then you're good. You're time barred. And they can't collect. And if they try to, they get penalized. However, if you're one of those rare individuals who has who lives that long and is able to get past the 60 years, then great. But if you don't have that, then you are still liable for this debt. Despite a loan modification, despite a bankruptcy, despite it being 15, 20, 30, 40, 59 years and 11 months, debt is still good. Debt can still be collected, even though no attempt to collect the debt heretofore has taken place. For 59 years and 11 months, nobody has said a word, and the debt is still collectible. And all of the past due interest is collectible, and fees and the rest are all still collectible. That's insane. That law must change. But that's how you fight them. You get into it, you get the data, fight them on their own grounds, force them to produce the data. And by the way, the Truth in Lending Act, Real Estate Settlement Protection Act, Fair Debt Collections Practices, and in California, the homeowner, it's really first mortgage, but the Homeowner Bill of Rights also touches on this. They have to give you that data within 30 days. If they don't, it's a RESPA violation. If you can prove a pattern of RESPA violations, you go after them. Hard to prove a pattern because every judge thinks it's different. But that is the way that works. So I tell you what, let's take another break. Let's hear from some of the advertisers again. And when we come back, we'll talk about the laws that need to be changed and how we fix this thing once and for all. And if you're a politician, you're within the sound of my voice, I am begging you, please call me. I will give you everything you need to change this law. You'll be very popular among your constituents. I don't care what party you're from. We will all be happy to vote for you. Please listen when I say this. Again, my name is Rich Szerman, and you're listening to The Real Estate Fix on KHTS, FM 98.1, AM 1220, your hometown station. And we'll be back after these messages. Thanks for listening, guys. Hello, everybody. Thank you guys for listening through the break. I appreciate it. You're listening to The Real Estate Fix. I'm your host, Rich Szerman, on KHTS, FM 98.1, AM 1220, your hometown station. Thank you guys for tuning in. I appreciate it. Hopefully, we've learned a little about zombie mortgages today. And we're going to wrap up the show. One last thing about what you can do if you have one of these things. And then we're going to talk about the laws that need to change. Because honestly, as crazy as these loans make me, as angry as these things make me, the part that makes me the angriest is most of the politicians working in California know darn well this is going on and have absolutely no interest in fixing it. I'll explain why when we get to that point. But I want to talk about this one last part here about defending yourself. If you do get nailed with one of these things, there are places you can reach out to. Obviously, you can call me. I'll help you out. I'm here. I'm happy to help. And again, my phone number is 661-714-1400. You can call me at that anytime, 24 hours a day. That's my personal cell phone. And if I don't answer, please text. I'll get to you, I promise. But in addition to that, you can also contact the CFPB, the Consumer Financial Protection Bureau. Now, unfortunately, the CFPB has largely been defanged of late, so there's not a whole lot they're going to be able to do for you. But they will send the occasional letter, and they will add your voice to the ones that they're hearing. And if they find a cumulative thing, like several hundred people are being taken advantage of by the same company, then they might actually do something about it. So it ain't great, but at least it can provide some help. You can also talk to HUD, same sort of thing there. Not a whole lot they're going to be able to do for you directly, but at least you'll get some information and they'll help point you in the right direction. You should also review the Fair Debt Collections Practices Act, FDCPA, Fair Debt Collections Practices Act, because if they threaten to sue you and you have a zombie that is illegal, that's time barred, it is illegal for them to come after you. And it says so in that in the Fair Debt Collections Practices Act. You should also look at the Real Estate Settlement Protections Act, RESPA, or RESPA, and the Truth in Lending Act, TILA, TILA. So you have those three to look at. The Fair Debt Collections Practices Act, if you're the research sort, the Real Estate Settlement Procedures Act, and the Truth in Lending Act. You should definitely look at all three of those laws because your salvation may lie there. We look at them, we review them all the time. But of course, you can always call me, I'll put you in the right direction. Now, let's talk about what needs to change. Because these are the things that drive me the craziest. Because I have lobbied about this in Sacramento with the help of the station, and I've talked to local politicians of every stripe, of every policy, of every party, and nothing seems to happen. And I will tell you this story as to why. Some years ago, I was caught with the former Speaker of the California Assembly, and he had just lost his seat, was retiring essentially from politics. And unfortunately for him, got caught on a plane with me coming back from Sacramento. Not a long flight. He was next to me, and I said, "Look, why is it that I talk about this issue all the time, and politicians on both sides of the aisle agree with what I have to say, agree with the changes that need to be made, and then nobody does anything?" And he said that the old Charlie Wilson joke, well, tradition mostly. Why does a politician do nothing? Well, tradition mostly. And it's a funny joke, and I get it, and I read the book, and Tom Hanks is good in the movie, and that's wonderful. I get all that. But I'm asking you a real question. Why is it no one does anything about this? This is damaging to your constituents. I can't believe this is not a politically popular thing. Why are you not doing anything about it? Why is no one doing anything about it? And he said something that I've lived with ever since, and I think about it almost daily, because it's so true. It just shot right through me, and it actually made me be quiet for the rest of the flight, which those of you who know me, that doesn't happen a lot. What he said was, no politician has ever lost their job for doing nothing. You lose your job for doing something that is not sufficiently popular. And if that doesn't tell you why this has not changed and is not likely to change anytime soon, I have no better way to discuss it. Politicians keep their jobs by doing nothing. They lose their jobs by doing things that are not sufficiently popular. So we, you, me, and everybody else who's in the sound of my voice, or people you know, have to make it important for our politicians to get involved in this fight, because it is damaging people's lives, it is taking their homes, it is destroying their retirements, and frankly, it is absolutely contributing to homelessness, which in this state is insane. We have 30% of the country's homelessness, we have 12% of the population. That should tell you we're doing it wrong. And by the way, contrary to popular belief, people don't move to California when they're homeless. 99% of the homeless population in California is homegrown. They're usually in the same county they started in. Not a whole lot of mobility for those people who are homeless. So this is what needs to change. These are the three things I want to focus on, if nothing else. These are the laws that need to change. There are three things. And if we could just change these three things, the entire zombie mortgage market goes away. These are the three. Number one, assignment of the note. When a note goes from bank A to bank B, you are supposed to get notice. That is the law. However, the law does not require actual notice. It doesn't require proof of mailing. Now, how are you, as the consumer, supposed to prove you didn't get a letter? It's a logical fallacy. You cannot prove you didn't get something. And the bank will certainly say, well, we sent it. Of course they're going to say they sent it. They have to. It's the law. But the law doesn't say they have to prove they sent it. Change one line in that law, make it actual notice, job done. Because then you would know when it gets sold in the secondary market, moves from bank A to bank B, bank C to bank E, et cetera, et cetera. You would know, and you'd know it was there, and you'd know you have to deal with it. So that's number one. Also, as part of that, they must immediately file with the recorder's office. The number of times we have to spend where we have to go to the bank and convince the bank they have the note. It's embarrassing. It's ridiculous. They don't even know sometimes. Number two, the statute of limitations has to be 4 or 6 years. It should be the same as a judicial foreclosure, which is 4 years, but at most it should be 6, not 60. 6 years maximum. That's what it's supposed to be, not 60. It is a perversion of the law that they're allowed to go to 60 years. And they damn well know it. That should be fixed. But most importantly to me, the homeowner should be given the opportunity to buy the debt for the same amount as an investor bought it for in the secondary market. If an investor buys a $200,000 debt for $50,000, you as the homeowner should be given 90 days to match that offer and buy the debt yourself and wipe it out. Those are the three things. If you could do those three things, no more. No more zombie seconds. No more zombie mortgages. That would wipe out that entire cottage industry that should be wiped out. These things are dangerous, they are bad, and they are costing people their homes. And this is very, very easy to fix if there is political will to do so. Other states don't do this. We do this here because it is profitable to do this here, because the politicians in our state have no political will to fight this fight. There is no political backbone that I can find anywhere in the state of California. And that's both parties. Nobody seems to want to get involved with this fight because they don't think it's sufficiently popular. So we have to make it sufficiently popular. That's what we have to do. So that is my rant on the subject. I hope you guys are listening. If you think you have one of these, if you know you have one of these, if you think you have a friend who has one of these, for goodness sake, please give me a call. You can reach me at 661-714-1400. I'm available 24 hours a day, 7 days a week, but don't answer text. I'll call you back. I specialize in fixing these things. We do it for free. We fix all sorts of problems for free in my office. I'm Rich Szerman. You've been listening to The Real Estate Fix on KHTS, FM 98.1, AM 1220, your hometown station. Thank you guys for listening. If you do have a problem with this, please give me a call back. Have a good week. Be good humans, and I will see you next time. Thanks, guys. Bye-bye.